Her name?
Kayla Bear.
What are we doing?
Your Honor, we are adjourning this matter. We do have but we did not submit the form in time.
We also have a bond violation.
Before this docket even finds its rhythm, you can already sense the pressure building. Today's courtroom session in front of Judge Simpson moves fast. Bond violations, missed drug tests, financial restitution, extradition questions, and a plea deal that completely unravels in real time. And watch closely, because this is where courtroom discipline meets human inconsistency. We're dealing with defendants who say there was miscommunication, who claim they didn't understand testing rules, who insist they didn't know a check had no account. But in this courtroom, assumptions don't override responsibility. Notice how quickly the judge drills down to the core issue. Compliance. Did she test? Does she have the funds? Is she clean? Those are yes or no questions, and when answers start drifting into explanations, that's when tension spikes. We're also going to see a plea attempt that collapses because of one critical statement, and later, a medical hardship argument that forces the court to balance accountability with compassion. So pay attention, because every word matters here, and sometimes a single sentence can derail an entire deal.
Not tested or gone back for testing.
Your Honor, I think there was some miscommunication with my client and reporting for testing. She was under the impression that she had to wait for notification that she'd be able to test in Flint. I think at the last PCC, we discussed that that's a possibility.
She indicated she would check out someplace close to where she was staying to test and get back to community corrections. She's not gotten back to community corrections, not called them back, not indicated anything. Neither has counsel.
Would she be able to test
The
today, Your
problem
Honor?
is that since that time, she's missed 2 tests. She's got to test or get us a place to test.
She is currently not working, Your Honor, and doesn't have the funds for transportation or test.
I'm home.
Would she be able to test today?
Does she have the funds today?
I can get the funds. Yeah.
Pardon?
I can get the funds.
I don't know what that means. Does she have the funds?
Yeah.
Someone's here with her, Your Honor. And we'll give.
Okay, all that tells me is somebody's here with her. Does she have the funds
They will
to
give her the
test?
funds to test, yes.
Get over to community corrections, test now. Come back. Are you gonna test clean?
Yeah, THC.
Do you have a card?
No, I have.
Defendant's bond's revoked, defendant's remanded.
Thank you, Your Honor.
Should have said no.
That offhand comment, should have said no, is more revealing than it sounds. It suggests regret about honesty in open court, and that's critical because credibility is currency here. When the defendant admits uncertainty about whether she'll test clean, the judge immediately revokes bond. Why? Because bond isn't a right. It's conditional liberty. When Judge Simpson says, defendant's bond revoked, defendant remains, that's decisive authority. The court determined risk outweighed trust. There's no negotiation once that line is crossed. Now think about that moment. If she had simply requested time to clarify testing compliance instead of hesitating on whether she'd test clean, would the outcome have been different? Or was the judge already convinced based on the missed tests alone? Sometimes it's not just what you've done. It's how confidently you stand behind your compliance that influences the court's perception.
Kirkhouse case, People versus Curtis Martin.
Your Honor, Alexis Puma appearing on behalf of Mr. Martin, who is present over Zoom. Mr. Martin, could you unmute and
what's
say
your
your full
name?
name?
Hold it. Who are you?
Quintel.
Oh, that's not you? You might like this charge better. No, I'm kidding.
Hello. Hey, how you doing?
Hello. What's your name?
Curtis Martin.
All right. I have before me a plea form that indicates that he's going to be pleading to attempted no account check, the 1 year, Upon the success, that's count 3. Upon the successful plea to that charge, counts 1 and 2 would be dismissed, and that the defendant would pay restitution in the amount of $2,299.98 to Costco. And also, there's agreement, but not binding the court, to a prosecutor's deferred sentence.
Yes.
People, that's my understanding of the offer up.
Okay. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record, sir.
Curtis Martin.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted no account check. Is that correct?
Yes, Your Honor.
That's a misdemeanor punishable by up to 1 year in jail, a $500 fine plus cost. You understand that?
Yes, Your Honor.
All right. This is mine.
Yes.
All right. So, sir, to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advisor rights form or went over it with your counsel and had her sign it on your behalf? Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
No, Your Honor.
Right. Do you understand that you're giving up all the rights that are contained on that advice of rights form?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
October 7th, 2023, at the location of 771 Airport Boulevard in Pittsfield Township, Washington County, State of Michigan. What did you do at the Costco that makes you think that you're guilty?
I took a check in there that had no account and tried to get an Apple iPad with it.
You tried to do what with it?
I took a check to Costco and tried to get an Apple iPad with it.
Okay. And what happened when you tried to do that?
Really, they and them letting me get the iPad. They and them letting me get it. I really ain't think nothing of it because I was with a female at the time and I really did not know nothing about the checks and nothing like that. I thought it was money in the account. I really ain't think nothing of it. I never did nothing like that. I was really running around.
Mr. Martin.
Okay, well,
Mr. Martin,
do
you remember?
Mr. Martin, I'm gonna stop you right there. And just based upon what you said, I cannot accept this plea to this charge.
This is a textbook example of a plea collapsing because of a factual inconsistency. Mr. Martin is pleading guilty to attempted no-account check, which legally requires intent. But listen to what he says. He didn't know about the check. He thought there was money in the account. He was with a female. He really ain't think nothing of it. That statement undercuts the element of intent. A judge cannot accept a guilty plea unless there is a factual basis for every element of the crime. What if he's claiming lack of knowledge, he's contradicting the admission of guilt, and Judge Simpson catches it instantly. This is why plea hearings are not just formalities. They're sworn admissions. One inconsistent explanation can invalidate the entire agreement, including the dismissal of other counts and a deferred sentence possibility. Would you advise a client to speak freely during a plea colloquy, or keep answers tightly aligned to the elements? This is where precision matters.
And so what I'm going to do, sir, counsel, what do you want me to do? You want me to set it for an exam? So we
Your
can find
Honor,
this female that, no. Do you want me to
Your
set
Honor,
it
I
for
would-
exam, or do you wish for me to adjourn the probable cause?
I would like to adjourn the probable cause conference. My understanding was this was an offer that Mr. Martin had asked for. So I
Okay,
would like to
gotcha.
talk with him.
That's fine. Probable cause conference Mr. Martin, will be adjourned October 16th, 2025, 9 a.m. or as your invite indicates, his bond at this time will continue. Thank you. Court calls the cases of the people versus Dimas, Paez, Madrid.
Alexander, on behalf of the people.
Your Honor, tonight on behalf of Mr. Paez Madrid. And sir, could you just state your full name for the record?
Good morning, Your Honor. Dimas Paz.
Thank you. And Your Honor, I am requesting an adjournment in both cases. I am attempting to negotiate a global resolution of these cases as well as 2 cases out of district court. And additionally, I would like to address bond very briefly.
Probable cause conference. When are the next, when you say district court, what district court?
14A2.
When's his next hearing on those?
October 9th.
I'll adjourn these matters to October 23rd, 2025, 9 a.m.
Thank you.
That's the bond.
Yes, Your Honor, my client would like me to request permission for him to reside in the state of Indiana while this case is pending.
We have, Your Honor. I believe he was extradited from Indiana for these cases, so people would be strongly objecting.
And Your Honor, I did have a conversation with him about that. I believe from what he tells me, he was picked up on an unrelated misdemeanor in Indiana, which is how he found out about these warrants, and he was then extradited to Michigan. However, he had been living in Indiana with his fiance and his son. Fiance is not the complaining witness in any of these cases. As he's been staying with someone in Michigan, he hasn't been able to work. His fiance has reached out to me several times and let me know that she is not going to be able to pay
I've
their
already
bills.
addressed this issue. I mean, actually, I'm surprised that somebody who's extradited is actually out walking around, to be honest with you, especially on these charges.
Understood, Your Honor. I did let him know that I would try again.
Okay, I understood. You tried. I don't need a response from the people. Motion for bond modification or reduction in terms of the ability of Indiana is like the last time denied.
The Indiana bond request is another powerful moment. The defense frames it as stability, living with a fiancé and son, ability to work, but the prosecution objects strongly, pointing out extradition, and that's key. If someone had to be extradited back to Michigan, the court is naturally skeptical about allowing them to leave the state again. Judge Simpson's comment that he's surprised someone extradited is even walking around signals how seriously he views the charges. Bond modification isn't just about convenience, it's about ensuring court appearance and community safety. Here's the engagement question. If a defendant was previously extradited, would you trust them to reside out of state again while charges are pending? Courts operate on patterns. Past conduct informs future risk. And in this case, that history closed the door immediately.
Thank you, Your Honor.
Bond will continue with its conditions.
And Stephanie Cannon on behalf of Ms. Shepherd, who should be appearing by Zoom, Your Honor.
She's there. Ms. Shepherd, can you state your name, please?
Ashley Marie Shepherd.
Thank you.
Thank you. Your Honor, we are going to adjourn this matter for mitigation purposes. When appropriate, I would like to address bond.
October 23rd, 2025, 9 a.m. Master bond.
Thank you, Your Honor. I've been in contact with my client regarding this case and her circumstance and situation. My client has COPD, and unfortunately, because of her testing, she can't take the medicine for it. So she is desperately struggling right now.
Because of what testing?
Because she is having to blow right now.
Got it.
And so she is struggling. When I spoke to her yesterday, she could barely catch her breath. But she's afraid to take a medicine for fear of testing positive before this honorable court. I am not, as far as the testing requirements go, the court, if looking at the information is accurate,
So
incident,
she's on a sober link?
she has to blow. She told me she's blowing. Yes.
Okay.
So she has.
Does she want to scram?
Your Honor, I would like Ms. Shepherd, would a scram work better for you since you have to inhale?
I don't know what a scram is. And I don't
It's a
have.
tether on, it's a tether that's on your ankle that will monitor you 24/7. You will not have to blow into a machine.
It
Um,
likely will give you the ability, however, to take your medicine.
Okay.
And Your Honor, I do want to point out that this case is from 2023. After this incident, my client did go to rehab. She's not had a drink since then. She's not been testing positive at all. And I understand the nature of these charges and how the court would have her monitored. However, if she takes this medicine and starts to test positive with the sober link as well, because it's like a butyrol, it's alcohol based, it's going to go into her system.
This section shifts tone dramatically. Now we're dealing with medical hardship. COPD, difficulty breathing, fear that prescribed medication could trigger a positive alcohol reading. The defense is arguing that compliance conditions are interfering with health treatment. Here's what's interesting legally. Technology matters. SoberLink requires breath samples. A scram tether monitors alcohol transdermally through the skin. Different mechanisms, different risk profiles. Judge Simpson proposes a solution rather than punishment. Modify bond conditions to a scram tether. This shows judicial discretion at work. The court isn't dismissing monitoring, it's adapting it. That's a nuanced move. Accountability remains, but medical necessity is acknowledged. Should courts be flexible when health conditions conflict with monitoring tools? Or does flexibility create loopholes? This balance between strict enforcement and humane adjustment is one of the most complex aspects of pretrial supervision.
Yeah, but we'd be able to tell.
I mean, if that is the case, would that work better for you, Ms. Shepherd? It will go
Yes,
around your
please.
ankle.
Yes.
All right. So I will grant without objection from the people, the defendant's request to modify bond and indicate that defendant is to report over to community corrections for a scram tether. Okay.
Thank you, Your Honor.
And then that way they'll take the sober link back, and I'm signing an amended order for placement on the scram tether, doing that right now. All right.
Thank you. And this was on 10-9 for the adjourned PCC?
What? Do they not hear? Her and Gaddy, they're not listening. They're just talking.
We're the same age.
Sorry to hear that. 23rd.
23rd. Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Thank you, ma'am.
Today's docket reveals 3 distinct courtroom outcomes. First, bond revoked for non-compliance, missed tests and uncertainty about sobriety. Second, a plea deal rejected because the defendant's own words contradicted the required criminal intent. Third, a bond modification granted, not because conditions were unfair, but because a medical circumstance justified a technological adjustment. Judge Simpson's courtroom demonstrates a consistent principle. Credibility and compliance drive outcomes. And excuses without action fail. Inconsistent admissions derail pleas, but documented hardship paired with transparency can lead to accommodation. The broader implication? Courtrooms operate on structured logic. Every statement is evaluated against legal elements and procedural standards. When defendants speak, they're building or breaking their own case. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.